Welcome to the McKinney-Vento Dispute Resolution Process webinar. My name is Cheryl Kosmanka, and I am the State Coordinator for the McKinney-Vento Education for Homeless Children and Youth program at the State Department of Education. Sean Cochran, the Director of Student Support Services that oversees the migrant, ELL, immigrant, refugee, and homeless education programs at the department, will be taking questions that are entered into the chat, and I will address those at the end of the presentation. McKinney-Vento Dispute Resolution Process webinar is one of the required trainings for all homeless liaisons for the 2022-23 school year. Let's go ahead and get started. Subtitle 7B of the McKinney-Vento Homeless Assistance Act, which was reauthorized in 2015 by Title IX, Part A of the Every Student Succeeds Act, guarantees educational rights and supports for students experiencing homelessness. The McKinney-Vento Act requires that every state have a state plan to provide for the education of homeless children and youth within the state. The plan must include a description of procedures for the prompt resolution of disputes regarding the educational placement of children and youth experiencing homelessness. The McKinney-Vento Act requires states to establish procedures for the prompt resolution of disputes regarding the educational placement of homeless children and youth. Districts are required to have a board-adopted homeless dispute resolution process. While it's not required that the districts use the state's dispute resolution process, the Act mandates basic protections and procedures that must be in place when a dispute arises. Therefore, it is highly recommended that the dispute resolution process at the district level closely align with the state's process. Okay, the dispute resolution. What is disputable? The Act requires state educational agencies and local educational agencies to follow a dispute resolution process when parents, guardians, or unaccompanied youth disagree with schools over eligibility, school selection, or immediate enrollment. We're going to look at these key provisions related to the dispute resolution, including in the McKinney-Vento Act. And I'm going to suggest strategies for the implementation at the LEA level when these disagreements occur. First, we're going to look at eligibility. What does that mean? When a child or youth, unaccompanied homeless youth, seeks to enroll in a particular school under the McKinney-Vento Act, does the child meet the definition of homelessness such that immediate enrollment in the school is required? Every district is required to have questions from the McKinney-Vento Act on all school enrollment forms to help determine McKinney-Vento eligibility. This includes new and returning students. Living situations can change at any time, so it's important to identify all students that are eligible that meet the McKinney-Vento definition of homelessness. We're going to review that McKinney-Vento definition you would use to determine eligibility. According to the McKinney-Vento Act, the term homeless children and youth means individuals that lack a fixed, regular, and adequate nighttime residence. It goes on to say, give some examples that may meet eligibility because they are not fixed, regular, and adequate. And the first one of those is sharing the housing of other persons due to loss of housing, economic hardship, or a similar reason. So it doesn't just say sharing the housing of others. It's due to loss of housing, economic hardship, or a similar reason. Families and youth living in motels, hotels, trailer parks, or camping grounds due to the lack of alternative adequate accommodations. And trailer parks in this sense does not mean trailer parks that we have throughout our state that are stationary and not actually movable on a regular basis. And trailer parks would include some areas similar to camping grounds where you have mobile trailers that move from place to place. Living in emergency or transitional shelters or abandoned in hospitals. Those families and youth living in a public or private place not designed for or ordinarily used as a regular sleeping accommodation for humans. Living in cars, parks, public spaces, abandoned buildings, substandard housing, bus or train stations, or similar settings. Or any migratory child that would be living in any of the above circumstances. Just to review, the term unaccompanied youth includes a homeless child or youth not in the physical custody of a parent or guardian. So actually unaccompanied youth is, a youth not in the physical custody of a parent or guardian. To meet eligibility for McKinney-Vento services, that student would need to be unaccompanied as well as meet one of the nighttime residence definitions for homelessness, receive services as an unaccompanied homeless youth. And the second disputable item is school selection. You're going to spend some time on this one. Is the child or youth's best interest to continue attending the school of origin or to enroll in the school attendance area school? Okay. Under the law, McKinney-Vento law, homeless children and youth have the right to attend the school of origin, which means it's the school that a child or youth attended when permanently housed, or the school in which the child or youth was last enrolled, and that would include public preschools or also receiving schools. Or the child could attend the local attendance area school. That would be any public school that non-homeless students who live in the attendance area in which the child or youth is actually living are eligible to attend. Every student that enrolls under McKinney-Vento and has transferred from another school district must be made aware of their right to return to their school of origin. Each student that is not returning to their school of origin should have a school selection / best interest determination documentation. Even if that documentation is case notes saying that the parent wanted the child to attend the school where they were now housed. Maybe the parent didn't have any plans to get back to the area where the school of origin was. But every student who is not attending their school of origin and has transferred into your district should have documentation of the decisions that would reflect reasons for the decision to attend the school of residence. We are going to talk about preschool because school selection and school of origin does also mean preschool. Do McKinney-Vento Act requirements apply to homeless children attending preschool? And the answer is yes. To the extent that an LEA offers a public education to preschool children, including LEA administered Head Start programs, an LEA must meet the McKinney-Vento Act requirements for homeless children in preschool, including ensuring that a homeless child remains in his or her public preschool of origin unless a determination is made that it is not in the child's best interest. I have included some information from Schoolhouse Connection that really goes a little more in depth about whether or not your early childhood program is a McKinney-Vento preschool. So I would highly recommend that you look at that information to help determine whether or not your LEA meets those requirements. Okay, school selection continues. So when you're in determining best interests, the school district shall presume that keeping a child or youth in the school of origin is in the child or youth's best interest, except when doing so is contrary to the request of the parent, guardian, or unaccompanied youth. You should also consider student-centered factors related to the child or youth's best interest, including factors related to the impact of mobility on achievement, education, health, and safety, giving priority to the request of the parent, guardian, or unaccompanied homeless youth. We use the term best interest kind of interchangeably in school selection. I just want to note that best interest determination that is used for foster care students is different than a school selection process that's looking also at a student's best interest. So the school selection process or checklist is different from the best interest determination process or checklist that is used for foster care. So if the parent or youth decides to return to their school of origin, they have that right. Enrollment must be immediate and transportation must be arranged immediately. If the district does not believe that the school of origin is in the student's best interest, a school selection process should take place and provide the parent or youth with the dispute resolution process for school selection. Homeless children and youth have the right to attend the school of origin for the duration of homelessness. In any case in which a family becomes homeless between academic years or during an academic year, and for the remainder of the academic year, if the child or youth becomes permanently housed during an academic year. So if you have a family that was identified and eligible for McKinney-Vento services in September, but they obtain permanent housing in December, they would still have rights to all of the McKinney-Vento services until the end of the school year, and that would include attending their school of origin. If they obtain permanent housing in another district, that doesn't mean that they have to enroll in that resident school. They would like to remain attending the school of origin for the duration of the school year, they have that right. I know that times it said that there a time limit to homelessness, and there is for some families. It could be true for some students that they can spend most of their school years moving from place to place and therefore continue to meet the legal definition for McKinney-Vento eligibility, which would be lacking a fixed, regular, and adequate nighttime residence. Homeless children, again, and youth have the right to attend the school of origin for the duration of homelessness. This is why you must reassess your children and youth every year. During that reassessment, you would, for example, if you have a family that has what you believe been in a fixed, regular, adequate nighttime residence for a couple of years, You would, during your reassessment, you would want to visit with the family and ask questions like, how long do you plan to stay at your current address? Do you plan to come back to the school of origin? Do you plan to get housing back in our school district? Make parents and youth aware that if the living situation remains fixed, regular, and adequate, student may no longer meet the definition of McKinney-Vento. If they have no intentions of returning to the school of origin, it may be time to enter into the school selection dispute resolution for school selection. Keep in mind that every single family and unaccompanied whose living situation should be determined on a case-by-case basis. Okay, the next disputable item is immediate enrollment. Is the child or unaccompanied youth attending classes immediately, even if the school has not received school records, immunizations, or other health documents? Is the child being provided full participation in school activities? Oftentimes, what I see with immediate enrollment violations usually are brought on because of questions of eligibility or school selection. So even if you do not believe a child or unaccompanied homeless youth meets the definition of homelessness or has a right to attend your school, you must immediately enroll and enter into the dispute resolution process. And a reminder, immediate enrollment means attending classes and participating fully in school activities. Kind of reiterate, enrollment must be immediate, even if students lack school, medical, or other records normally required, even if enrollment or application deadlines were missed while homeless, or even if a student has a history of absences or outstanding fines or fees, or those students must be immediately enrolled. I often hear with immediate enrollment violations that the student was not immediately enrolled because the school was not sure of their placement. Without transcripts or records, this may be a challenge. I believe this can be rectified by using quick assessments or having conversations with the student about their past school experience. Determining placement should be handled like it would with any student. I also often hear about cases where there's concern about safety to the other students in the district. I completely understand that those situations happen. And what I would suggest in those cases would be to call in your resource officers, your social workers, your counselors, anyone that can help in gathering information. And as long as you're documenting that you are involved in this process before the student is actually placed in a classroom, as long as you have documentation that you are working towards that placement, then that would be fine. I mean, you have to document the reasons why that enrollment did not happen immediately. Okay, what are LEAs required to do if a dispute does arise over eligibility, school selection, or immediate enrollment? The Act requires that the LEAs take the following steps. Again, the child or youth shall be immediately enrolled in the school in which enrollment is sought. Okay, so even if the school district believes that they shouldn't be at their school, but that's where the parent or unaccompanied homeless would like to enroll or remain, they have that right. And they have that right pending final resolution of the dispute, including all appeals. The parent, guardian, or unaccompanied youth must be provided with a written explanation of any decisions related to school selection or enrollment made by the school or LEA involved, including the rights of the parent, guardian, or unaccompanied youth to appeal such decisions. I have included a form. It's a notification of decision. You are absolutely welcome to use. It's a simple way to get a written explanation out to the parent, guardian, or unaccompanied youth. It also includes a form for the parents to fill out if they would like to respond and enter into a formal resolution with a formal complaint. LEAs are also required to refer the parent, guardian, or unaccompanied homeless youth to the LEA's liaison, who will carry out the dispute resolution process described in the LEA level dispute resolution policy as expeditiously as possible after receiving notice of the dispute. And in the case of an unaccompanied homeless youth, the liaison must ensure that the youth is immediately enrolled in the school in which the youth seeks enrollment pending final resolution of the dispute. And the liaison will also help support that unaccompanied homeless youth during the process. Talk a little bit about the written explanation. Like I said, the LEA must provide a written explanation, including the reasons for its determination and information regarding the right to appeal in a manner and form understandable to the parent, guardian, or unaccompanied youth. Again, I have a link there to a notification of decision that you can absolutely use. I believe it's a simple form, but you are also required to attach to that form your district's formal policy for the McKinney-Vento dispute resolution. So, and that can get a little complicated or maybe a little bit more difficult to understand. So it is the liaison's duty to make sure that families and youth understand the process. We will talk a little bit again, just reiterate full participation means while the disputes are pending, students have the right to participate fully in school and receive all services for which they are eligible, including transportation. The definition of enrollment includes attending classes and participating fully in school activities. The LEA Liaison has the authority and McKinney-Vento Act responsibilities and duties to ensure that eligible students are identified. This should be a collaborative effort with school personnel and through outreach and coordination activities with other entities and agencies. And that coordination piece is a requirement of the McKinney-Vento tiered monitoring, that you show evidence that you are coordinating these identification processes with your school personnel, with your local community partners and agencies. There is a I've included the link to an eligibility determination document from the National Center for Homeless Education. You're welcome. It has good information about determining eligibility. Okay, we are going to take some time to look at some eligibility, school selection, and immediate enrollment scenarios and see to kind of help understand what some of that might look like. Okay, so you're beginning your first school year as your district's local liaison. It's August and students are enrolling for the coming year. A principal calls you with a question. A teacher wants to enroll her niece, Sasha, in his school, but he's not sure that that's okay. The niece moved in with her aunt, the teacher, over the summer because her father, who is a widower, moved to a new city to start a new job, but he wants his daughter to finish her senior year in high school with her friends. The teacher doesn't have all of the paperwork needed to enroll her niece, but says that shouldn't be an issue because Sasha is unaccompanied and can enroll under McKinney-Vento. Would you deem Sasha eligible for McKinney-Vento services as an unaccompanied youth? How would you respond to this caregiver? Okay, so it is absolutely true that Sasha is unaccompanied, living with her aunt because she is not in the physical custody of a parent or legal guardian. But we look at the definition. Did Sasha lose housing? I mean, is she with her aunt sharing the housing of another person because she lost housing? Or was this more of an arrangement by the father to keep the child in school where she would complete her senior year? My answer is that this does not meet the definition of McKinney-Vento because the student didn't lose housing. It was an arrangement made by the father and the aunt to remain in that school to complete her senior year. So Sasha, again, is unaccompanied, but to receive McKinney-Vento services, you must meet the, she would need to meet the definition as an unaccompanied homeless youth. So she would have to definition of homeless as well. Okay, another eligibility scenario. Franklin and his daughter Violet had to go stay with Franklin's mother after they were evicted from their apartment. Referred to you, and you were able to designate Violet as homeless right away. Her grandmother's home is out of your school, so you also arranged to keep Violet in the school of origin where she's been attending ever since. That was over a year and a half ago, and the new school year is about to begin. You check in with Franklin, you ask him how much longer they'll be at his mother's home. He says it's become apparent that his mother's health is not what it used to be. As a result, he's not sure when they'll be able to move out because they need to work out a care plan for his mother first. However, he stresses that it is still their plan to get a place of their own for him and Violet as soon as they can. You consider Franklin and his daughter to be homeless. How would you respond to Franklin? Well, absolutely. The initial eviction qualified his family as homeless and McKinney-Vento services. It does appear now that this living arrangement has become permanent, but during your reassessment, you would want to ask, is this fixed, regular, adequate? Does everyone have enough space? And where would you go if you couldn't stay with your mother? Or, he already said that he has plans to purchase a home once everything is situated with the mother's health. So you would need to ask certain questions. Again, this is a case-by-case basis, but as a district, if you believe that this has really become a permanent situation, you would want to give that written explanation to Franklin and include with that your district's McKinney-Vento dispute resolution process. A school selection. It's August. Mr. Warwick goes to Vander Middle School to enroll his daughter Stephanie in 6th grade. Ms. Jensen, the Vander enrollment coordinator, calls you, the local LEA Liaison, to ask for clarification. Mr. Warwick explained that his family has been staying in a shelter since April, but that Stephanie was able to stay in her same elementary school, Temple Elementary, last year under the McKinney-Vento program. Mr. Warwick's family is still in the shelter, and he's not sure when they'll be able to get permanent housing. He wants Stephanie to go to Vander Middle with her Temple Elementary classmates, even though it's not the middle school zone for the shelter. Ms. Jensen asked if it's okay to enroll Stephanie in Vander Middle. Does Stephanie have the right to enroll in Vander Middle School? Yes, Stephanie does. Vander Middle School is a feeder school of Temple Elementary. So because Stephanie was identified as McKinney-Vento eligible at Temple Elementary, and Vander Middle School is the feeder school of that elementary school. She has the right to attend Vander Middle School. Again, if this should not be a dispute because the district is allowing the father to enroll his child in the school that he's for. Their school selection scenario. Sharina is a 10th grader who you, the local liaison, identified as an unaccompanied homeless youth in February when she was attending Smithville High School. This is just a Smithville High School. This is not a scenario from actually, I realize we have a Smithville district in our state, so this is just hypothetical. She's been bouncing around since then and is now living outside the attendance zone of Smithville High. It's now July. Sharina calls you to let you know that she tried to enroll in Smithville High for the coming year, but the Smithville principal told her she could not enroll because he thinks she should enroll in the school zone for where she is staying. Sharina told the principal she wanted to stay in her school of origin and wanted to initiate a school selection dispute, but the principal told her only her parents can do this. Sharina calls you to ask if this is true. Can Sharina initiate a school selection dispute on her own behalf? Absolutely. Sharina is an unaccompanied homeless youth. She can initiate the dispute resolution process, and the homeless liaison is required to support and guide Sharina through this process. So the homeless liaison would provide the explanation of why the principal believes that she does not have the right to enroll in her school of origin. This also could be resolved at the district level if the homeless liaison would communicate with the principal and help that principal understand that based on her McKinney-Vento living situation and her eligibility for McKinney-Vento services, that she does qualify to enroll. So that this may not end up being a formal dispute resolution or process. It could be resolved with the liaison talking to the principal, and at all possible, we like to resolve disputes as quickly as possible and without having necessarily to go into a formal dispute, but you have to offer that option each time there is a question of eligibility, school selection, or immediate enrollment. Okay, immediate enrollment. Jessica showed up to enroll at a high school in your district last week. You, the local liaison, learned that Jessica ran away from home about a week ago and had been staying in a nearby youth shelter. You allowed Jessica to enroll herself as an unaccompanied. Yesterday, the principal at Jessica's school called you and said he received a call from Jessica's mother insisting that Jessica can come back home anytime, so she is not homeless. The principal asked you why you enrolled Jessica as an unaccompanied homeless. Can Jessica's mother dispute the school's actions? The answer to that is no, because Jessica enrolled as an unaccompanied homeless youth. It is Jessica's determination whether or not she wants to dispute immediate enrollment or school selection or eligibility with the school. This is similar to the last scenario, is that the homeless liaison could meet with that principal and help them understand that under the McKinney-Vento Act, that districts are required to immediately enroll unaccompanied homeless youth without question, and offer that dispute resolution to the unaccompanied homeless youth if there is a question whether or not they're eligible or school attending the school school that is requested. Jessica's mother is really disputing a decision made by Jessica. And though it appears that it's a decision made by the school, and a mother disputing her child's decision is not really disputable under McKinney-Vento. That would be a separate conversation that the district would have with the mother. Okay, Miss Green contacted the preschool in the district where she and her child were temporarily housed. Preschool indicated that there was a spot for the child, but because the school year was almost over and assessment requirements and lack of records for the child's school of origin, they could not enroll the child. Can this mother initiate the dispute resolution for immediate enrollment? Absolutely. So they told the family there is a spot for the child, that really what was holding up immediate enrollment was that the assessment requirements and lack of records, which should not be reason to deny immediate enrollment. And I talked about that earlier, that, and I get this oftentimes near the end of the year, that districts say, well, we have someone trying to enroll, we only have a few weeks left of school, and it doesn't matter. I mean, if the family is wanting, or an accompanied homeless youth is wanting to enroll, you must immediately enroll them and provide written explanation why you believe otherwise, and provide the dispute process for that family. Or I just want to mention the non-regulatory guidance, the homeless non-regulatory guidance on our website has a section that talks all about the dispute resolution process, the best practices, minimum standards, what type of situations fall outside the perimeters of the McKinney-Vento dispute resolution process, implementing an informal process. So there's lots of good information on in that document. In section K of the non-regulatory guidance, and there is a link to that guide. Also, the certificate of completion is available for verification of this required training. When you, the link to this certificate of completion will bring you to a short form where you fill out your name and email address, and once you submit that form, you will receive an email with a link to the certificate of completion that you can print and use as verification if you are cohort 3 and you are doing the tiered monitoring for the 2022-23 school year. You would want to include that certificate as well as the other required training, which is the McKinney-Vento tiered monitoring process. That even if you are not part of the tiered monitoring for the country, you would want to print this certificate and keep it in your file so that you would have that for verification required training. My contact information, please do not hesitate to contact me anytime. I'd be glad to take your calls, your emails. So this completes required training for the McKinney-Vento dispute resolution process. I would like to thank you for joining today, and especially to thank you for all you do to support the McKinney-Vento program and our students and our families that are experiencing homelessness. Take care.